Hello everyone, I'm Mehak Zaraq and welcome to ADR Initiative's Alliance series, where we are bridging the distance in dispute resolution to peace. This week, we are honored to have with us Ms. Aşiyan Süleymanoğlu and Ms. Ece Dayıog to enlighten us about alternate dispute resolution, Turkey, and COVID-19. In our previous webinars in the Alliance series, we discussed the need for alternate dispute resolution as the court systems in Pakistan have been failing to provide speedy remedies to people and more so during COVID-19. Our discussions showed us that there is a wide gap of conflict resolution that needs to be bridged. And in order to do so, we need to train the dispute resolution specialists and give them a structure to resolve disputes constructively. Also realize that there is a lot of change that needs to be done in Pakistan to tackle issues of adequate training, implementation of awards, understanding of online dispute resolution, and creating awareness of ADR, just to name a few. And in order to do so, we need to train the dispute resolution specialists and give them a structure. Here we will be discussing with our esteemed panelists how Turkey has strides in the dispute resolution mechanisms of mediation and arbitration, and I would like to begin with introducing our highly respected dispute resolution specialists. Firstly, Ms. Aşiyan. She specializes in dispute resolution and practices as a professional mediator, negotiator, trainer, and conflict management consultant. Dispute resolution mechanisms, mediation, and arbitration, and I would like to educator and an independent advisor on mediation policy to international bodies and national governments. She runs a busy national and cross-border mediation practice alongside teaching and training. Founder of the Athena Consulting, which develops innovative training materials and provides international consulting services on project design, management, and implementation. She has more than 15 years of field experience working on international ADR projects. She began her international career with the World Bank projects, continued with European Union projects, and then joined the American Bar Association Rule of Law Initiative, MENA Division, in 2009 as a program manager. She is one of the first mediators in Turkey and was selected as a JAMS Foundation International Weinstein Fellow. Since 2015, under the FCO grants, she acted as the program consultant and the director of the Improving Access to Justice Turkey through the ADR mechanism. Sponsored by the British Embassy in with the Association of Ministry of Justice Mediation Department. She directed a negotiation project called Mediation at the Grand Bazaar, where she ran a public awareness campaign and improved the implementation of Turkey's law on mediation for the dispute resolution of over 3,500 shops in Istanbul. She mediated over 300 disputes. During her career, she has worked with the businesses, chambers, lawyers, judges, law faculties, bar associations, and human rights organizations in a number of countries, including Turkey, Syria, Iran, Egypt, Pakistan, and the Philippines. She acted as a judge in international mediation and negotiation competitions of ICC Paris and IBA Vienna, and presented at mediation conferences in many countries. She holds a Master's of Law in Rule of Law for Development from Loyola College, Chicago University, and a diploma in law from Istanbul Bilgi University, Turkey. She is also a visiting scholar at Columbia University Mediation Clinic in New York. It is an honor to have you with us. Our second guest is Ms. Ece. Ms. Ece is a double qualified lawyer admitted to the Paris Bar and to the Istanbul Bar. As a seventh-generation lawyer of her family, she has continued her over 100-year-old family legacy through Dayıog Law Firm, and she's a partner there. When it comes to her arbitration practice, alongside her international litigation practice, she's an active arbitration practitioner in the fields of international commercial and investment arbitration, including but not limited to the disputes involving state parties. She is a former intern of the Special Counsel Mirza Philippe at the ICC International Court of Arbitration, Paris. She has equally worked for the MENA arbitration case management team of the ICC as well. during which she drafted a report in connection with her experience at the ICC. As for her academic background, she has obtained her LLB from Galatasaray University in Istanbul, following she did her LLM from Queen Mary University of London in International Dispute Resolution and Economic Law. Then she did her second master's at Pantheon Sorbonne University Paris in Arbitration and International Commercial Law, with an International Law Award. In connection with her postgraduate studies, she has obtained a customized scholarship from the French government, granted due to her academic background. She wrote her thesis on enforceability of arbitral awards in international arbitration involving states and state-owned agencies. She is currently a member of many arbitral organizations as she acts as an arbitrator during national competitions, and she's a contributor to the Paris Baby Arbitration. She equally works on her LLM thesis for her third master's degree at Istanbul Bilgi University in Business Law. Thank you so much for being with us. It is such a great pleasure to have such accomplished professional women today with us. So thank you, Aşiyan and Ece, for taking out the time for this so we can benefit from your expertise and experience. We will be discussing in general about ADR culture development in countries and looking at specifically at the Turkey model for both mediation and arbitration and see what we can learn from their triumphs and trials. For my first question, I would like both the panelists to weigh on this. Firstly, for the benefit of my audience, I would like to ask both my panelists that what is ADR to them and explain their areas of expertise and experiences with it.
Okay. First of all, I would like to thank you also for ADR Initiative and Mehak for this chance. And I'm happy to speaking again with also coming together with Pakistani colleagues. I've been in Pakistan for several times, as you also mentioned, for trainings. And what ADR means for me actually ADR is a general term for alternative dispute resolution, is an umbrella term which covers many different dispute resolution methods like mediation, arbitration, negotiation, settlement, conference, in some case neutral evaluation. But mostly I'm from the beginning, I always interested in mediation. And never worked in arbitration or any other except negotiation part. So basically my experience about ADR is based on mediation. And when I started interested in mediation, I think this is also interesting for your audience. I was a student. It was about nearly 15 to 16 years ago. And I was a legal clinic student, and we had one guest from Europe, and she mentioned about first time that I heard about mediation. And I realized that even without knowing this, what is it, I was trying to help people facilitating their negotiation process without knowing it is called mediation. Actually, basically, what is mediation is as a third party, as a neutral, you are facilitating mostly negotiation process of the parties. And I realized that I'm helping parties with this method, and also at the end of the process, they are much more happy with the outcome. So I started to interested in and research about mediation, and I got my trainings, and then I started to develop Turkish practice in mediation. Of course, it wasn't easy. It was a quite new concept. We have still many challenges, but comparing the past, there is a big process, at least for the knowledge and awareness about the parties. And right now the demand also is different, and I will explain more about this. So just short introduction about it. Ece,
all right, thank you so much for that, Ece. I think Ece is mute. We can't hear her yet.
Okay. Now can you hear me? Okay. So firstly, I'm humbled to be today's guest and equally honored to be a part of the ADR Initiative family. To begin with, I'd like to thank you for bringing up this important topic of ADR, Turkey, and COVID-19. As for your question, the ADR. Okay. Now can you hear me? Okay. So firstly, I'm humbled to be today's guest and equally honored to be a part of the ADR Initiative family. The ADR means the Alternative Dispute Resolution. In my experience, it includes any form of conflict resolution outside the practice that falls within litigation. The term pops up when there's a dispute to be settled outside national courts or international institutions. The ADR includes arbitration, mediation, conciliation, and even negotiation. In practice, there is no such thing requiring the process directed or supported by people with legal background. From my point of view, there is a common misunderstanding of the outsiders, let me say, which is that an arbitrator must definitely have a legal background, such as an LLB. Having said that, there are some ADR methods, such as party-directed mediation and negotiation. The ADR refers to processes and techniques which eases and shortens the litigation process. This is the reason why the ADR has become very popular among the parties, such as investors, contractors, energy contractors, etc. The beauty of the system is that be it arbitration or mediation, it is flexible and, dare I say, tailor-made, which can be customized for each dispute. Speaking of arbitration, parties can shape the process beforehand or even after the dispute has arisen. It means that in contrast to litigation, parties are entitled to set forth the terms of the process and determine law governing arbitration, language, procedural law, place of arbitration, and also the main criteria playing key role for the choice of arbitrators. As you have mentioned before, I act as legal practitioner in France and in Turkey. I attend court hearings, take active part in disputes before national courts. My expertise areas being domestic and international commercial and investment arbitration, business law and international commercial law litigation. I personally pursue a career divided into litigation and arbitration. So basically, my days are torn between Paris and Istanbul, if not in another city all around the world where the arbitral hearings take place. I also have the advantage of experiencing different fields of practice due to being the partner of my family's law firm. To recap my arbitration practice, currently I'm counseling constructors, energy contractors, investors, and businessmen in petroleum, aviation, construction, investment, and commercial arbitration disputes, some involving state parties and or state-owned entities. I'd like to say a couple of words regarding my ICC experience from the inside. I have participated in the ICC International Court of Arbitration sessions as observer. I have done legal research and drafting, follow-up of the arbitration cases, reading, commenting, and drafting of documents related to arbitration cases in English and in French. I have contributed to the writing of articles, ad hoc assignments as requested by the case management team. It was rather, for me, nourishing experience to witness a large number of arbitration cases, to administrate them, to take part in the challenge of arbitrators, and and also to get in touch with highly regarded arbitrators from all around the world.
All right, thank you so much for that, Ece. I would like to begin with the mediation model of Turkey, and I would like to invite Aşiyan to explain what is the Turkish model for mediation and how did society develop a culture for mediation?
Thank you, Mehak. As I said, it wasn't easy at the beginning. I said there was a long discussion, especially in the parliament, about the mediation law. And for instance, I started in 2005, and there was a discussion about the draft law, but the main law entered into force in 2012. And there was a 1-year period for the adoption. And in Turkish model, the main body for the mediation authority is the Minister of Justice. So there is a mediation department under the Minister of Justice. In order to be a mediator in Turkey, first you need to take a certificate program, and after that you need to pass the exam. Then you can register under the Minister of Justice list and become a mediator. So when the law first started, it was only Turkish model was a voluntary-based mediation, and we have quite small amount of mediations ongoing. But in the meantime, the government is seriously committed to practicing mediation. So therefore, there were running different types of projects that involving the business associations, not just the legal community, also for the NGOs, civil society, that explaining what is the mediation process and what is the beneficial for the access to justice. Then ministry realized that after this type of projects, promotional activities, mediation started to some movements. And they see that by voluntary based, especially for the labor cases, there is a quite high amount of success. So they see that if we're gonna pilot it for the mandatory mediation, why don't we start, since there's already practice in labor disputes. So in 2018, we have started to mandatory mediation model. By mandatory mediation, what I mean, especially to going mediation is not just the whole mediation process is mandatory. Only the first meeting for the parties is mandatory. It is prerequisite for the court case. So if you don't go to mediation, you cannot apply for the court. And this meeting is only also limited for 2 hours. So it is like a trial for the parties. If they have a resistance, if they don't see, they will not lose anything. They are coming the process, they are meeting with the mediator. If they don't want to settle, then they can still go to court, and whole process is, and they are still reserving their rights. And also, especially the Turkey, first of all, follow the Italian model. Italy also has similar model, but we have one differences, as basic differences from Italian model is this: if this mediation process resolved by parties agree, then party is paying for the mediator. But if there is no settlement, and the government is paying for the mediator's fee. So first 2 hours, not just the application is free, but also for the even if they don't settle, they are not paying for the mediator. So it's no cost for the parties. Although at the beginning there was a resistance, especially coming from the legal community, I mean, they become familiar with this process. Why? Because in every company, every person has sort of labor disputes. So it's quite common in many companies. Maybe not every company has a commercial or consumer case, but at least they have one case. So they get familiarized with the process by using. So it was quite effective. And when I'm seeing the results, I mean, when we started like in the first years coming to the 2018, there were only 30,000 cases settled through mediation. Now we have 1 million case go to the mediation, even more. And when I'm seeing the success rate is the 65% is the success rate of this. So there is a quite decrease about also the number of cases, especially for the labor. And the following year, we followed the commercial disputes. So the following year, based on the success of labor disputes, the government pushed for the commercial dispute to try mediation. So even for comparing to labor law, it is much more difficult, commercial cases. And we see that it is, again, more than 50% success rate for the commercial disputes as well. So, and now this year, consumer disputes also become a mandatory system. What this caused for in Turkey, right now, at the beginning, nobody knows about mediation so much, but now almost every lawyer knowing what is mediation. And even they tried, they have many experiences to seeing different kinds of mediators. Also, parties familiarized with the process. Now they are attending, and companies especially knowing mediation more. And right now, without applying for instance, mandatory mediation, they are willing to go to voluntary-based mediation as well, because they already experiences, and now they realize that which type of case really suitable for the mediation. So without going to court, they are now, nobody needs to force them by, they see the product, they see the benefits, so now they are requesting mediation.
Yes, I agree with that.
Mm-hmm. And I'm seeing, especially right now, in the first year, I had also quite difficulty with, especially not dealing with parties, dealing with lawyers, especially, I can say that. But now, lawyers see the also benefit of mediation. And now they are knowing how to work with the mediator. At the beginning, they are not prepared for the process, but now they are coming in a preparation. Also, they are like, I worked in US, in UK. When I observed mediations over there, I was surprised because in our lawyers are not prepared as mediation process like that. But now they become familiar, and they are also in cooperation with the mediators. That's why they want to apply or use more mediation process.
Thank you so much for that in-depth, enlightened model of what Turkey has done, starting from labor laws and labor disputes, and how then an awareness was made. And then there were developments. But what do you think are the shortcomings of the Turkey model of mediation, and what developments do you think can help it?
I think, first of all, there was some problems about the training of mediators, which is quite crucial, actually. And I need to comment also, in Turkey, and only people who law faculty graduates can be a mediator. So it's not allowed for other types of professionals. So comparing to US-based and UK-based models, and when we look our education system, I think also in Pakistan is the same. We only get legal training. So we only know how to think about legal framework. But in mediation process, you need to know also psychology, you need to know also business, and you need to be open-minded. And the way that how we trained is quite difficult at the beginning. So people need time, especially legal professions needs time to think openly, broader sense. When you see out of the box, when you train like that, it is quite difficult. So in that sense, as legal professionals have struggling to understanding the mediation mentality. And also, when we started, nobody has so much experiences. We didn't have a chance to get so much mentorship from the people that practice. But mandatory mediation, on the other hand, give a chance to mediators practice. Sometimes you learn by doing mistakes. So we do lots of mistakes, and there were at the beginning lots of problems in the mediation processes. But now it is developing because people see also quite good and talented mediators as well, and some also really not good applications as well. So they know, they compare right now, and the trainings also, the quality of trainings increase because mediation trainers become an experience. So we had a story to explain to the parties and also for the audience now to understand, because mediation is, when you really explain, it's not theory based, it's all practical oriented. That's why it is quite important to parties to have, to mediators who have practical experiences. I think it is developing right now in Turkey. And the other thing, we have started quite fast. Of course, when you start fast, you miss, it's not started within small area, it started within big. So there were also problems right now. The amount of mediators is quite high, and nearly more than right now to 15,000 registered mediators. So also quality control is an issue, and to whether they are using mediation centers, their mediation offices are suitable for mediation or not. It is quite difficult to control such a high amount of mediators. So this is another issue of the quality control. But right now, as I said, the mediation law was behind 2012, and nearly 8 years passed. Now we have a new law coming, which is going to possibly respond to these shortcomings, especially trainings, the status of ADRs and the mediation centers, and also the quality and monitoring for the mediations. And what I see, and other thing that I would like to say, and I also work with other countries, and this is a quite basic mistake that mostly many countries making, is for promotional activities or are only limited with legal professionals. I'm seeing, and especially the end user is the public in the mediation. So you need to involve business, you need to involve NGOs in this process, and you need to get their feedback. Because if we look to features of mediation, it is a voluntary process by feature, but we push and make it first meeting mandatory, let's say. But at the same time, we are saying this is a flexible process. The more you legalize, the more you have a problem, and it becomes a different thing than mediation. Right now, what I'm seeing in Turkey, also it becomes so much legalized. I'm seeing in the practice people saying, as a mediator, you cannot do this. And I'm saying it depends. Because it's a unique to the parties, and if they want to do something, then I need to be flexible. But if you too much legalize this, and then you are limiting the practical experience of mediators. And this might be a problem right now, what I'm seeing upcoming. And I will give a simple information, especially for the fees of mediators. For instance, since whole mediation laws and regulations practiced by legal professionals and mostly lawyers and law professors, they made the fees according to lawyer's tariff. So we are getting percentage if there's a settlement at the end of the process. But if you look as a mediator and the process is a mediator, I need to be neutral. If I have a benefit from the outcome of the parties, then I cannot stay neutral. So if I can convince the parties some much more up price, then I will get more. So in that sense, this is not really fit with the mediation process. But I'm seeing, even if the new law preparation, lawyers are insisting about getting the percentage. And I can understand the reasons, but on the other hand, the first thing that the party is asking is about the mediation fee. They are choosing mediation in order to have a clear background and also for the future. If my fee is unclear, so it makes the process unclear. So I think it's quite important to get the feedback to whoever uses this. Otherwise, there will be always shortcomings. And I think in order to minimize this, I think end users needs to be involved in the lawmaking process as well.
You mentioned a new law coming. Are these concerns going to be addressed in that law? Is there going to be some mediation, like will the mediator's conduct be regulated by the new legislation?
There is a mediator's conduct, actually. It's already comply with the international standards as well. But as I said, the quality, even if you have a good contact, that whether really mediators apply this or not, you need to control over the process. And on the other hand, there is not any feedback, not in the court proceeding, also for voluntary-based mediations as well. So as I said, for the parties and whoever use the mediation process, also including lawyers that attending the mediation process, we need to get their feedbacks. But I'm still seeing that many regulations are done by academicians and also for practicing mediators as well, but not my comment is important in that sense. Whoever uses is important in that sense. Only for if mediators or law professors comment on some shortcomings, that this is going to be in the new regulation. But still, a big part of the party's comment is missing, according to my point of view.
All right. I agree with you that the end user is the people, the common people, and they should have a say because it's the product or the service is something they will be using.
Yeah.
What do you think are the lessons that one can learn from the Turkish model of mediation?
I think if you have a good product, that if you give an option to use by the parties, then they are willing to use it. So the high number of cases that go into mediation is show that actually public like this. Why they like this? Because it's if they go to court, it will take so much time. They might not, even they might win the case, but maybe the party disappeared. So in many even big companies, we cannot say for what is going to be their future. So there are lots of uncertainty going on, especially after the COVID period, it increased more in many sectors. So in that sense, this is the process that party is in control with the decision. So they have decision power for the outcome as well. And I'm seeing also at the beginning, they have a resistance, but if you are bold and not, I don't want to say push, but to be persistent about the process, I think after they try, if they benefited, they will use again. So in that sense, what I'm seeing, and many countries are facing, especially to explaining parties what is really mediation, and adults learn by an action. I think the biggest outcome and learning that for us, mandatory mediation also for the Italy, that they learn it by an action. Before this, we were visiting the business associations, we were visiting the people, we were telling about mediation. They were saying, okay, it's nice. But at the end, without trying it, they cannot imagine. But when they try, if the process also managed by a really good mediator, they will benefit it and use again. What I saw in the Turkish experience.
I have a question. From my understanding, the settlement agreement turns into a court order. Is that why it is easier in Turkey to implement the mediation?
Mm-hmm. One of the reasons that I said it is limited by the legal professions, especially, is related with that, because the mediation agreement, the settlement agreement, and the end of the process is like a court order. So you cannot apply court again for the similar claim or accusation again. So it is the final like a wording, and that's why many companies using for this right now as a mediation as a prevention, even without going to court. If they know that some type of issues might become a dispute in the future, so they are signing now, they are negotiating now with a mediation agreement, so that the parties cannot apply court again.
All right. Thank you for that clarification. And how has COVID-19 changed the mediation model in Turkey? Is there more online dispute resolution?
Yes, and today I did 3 actually. And I talked to some lawyers that also they are quite happy right now because they in some law firms has many mediations at the same day, so they had a problem to arranging, because in such like a big cities it is difficult to go from one place to another, and that's why scheduling mediations was quite an issue for many lawyers. And now we are doing online or by teleconference, by phone, and it is easy and to schedule, and they are not losing time for the road. So they are quite adapted this model, and we have some e-signatures that even we don't need to use by electronic signature, they can sign. So every transaction is run by electronically, and the party is and also quite like about it to making. So if they were in another city, most of the time for the labor disputes, and this is the case, even the companies here, the parties in the other city, so they need to come for the mediation meeting. Now we are doing online and they don't need to come, and they are quite actually see that this is really working well. Of course, there are some challenges to have online meetings as well, and to affect the party and to communicate with the parties sometimes is difficult. Also, you need to have really good technical experiences in order to not to have technical issues. But still, I think in countries like Turkey and Pakistan, also similar, has quite young population, and we were consulting our families, our teachers, our mentors, but the new generation is learning by the phone. So their main address.
Sure.
And by mediation is a process other than parties coming you, sometimes you are going them, and this make them is quite also new generation really adapt easily to this process. And actually, I am also learning technical issues from sometimes young parties in mediation. Another issue is, I think it's related with many countries, is because of COVID, the number of disputes is definitely increased, and because the structure hold the companies, and especially for the supply chain groups, and many restaurants were closed, and so there are more disputes, maybe more conflicts than any other terms. And so in that sense, the courts possibly had problem in the past, but now they will have much more case applications, and even to getting a day from the court is starting from November to December. People do not have time to lose. So that's why they are thinking more and applying mediation, because it's time. The legal process is quite time consuming, and they need to also clarify their disputes, and they want to make a clear future for themselves. So I think I'm seeing, because after the COVID, people are much more accustomed to use models like mediation and arbitration, because they need a quicker decision.
It's heartening to see that now people are taking control of their own disputes and their own fates rather than leaving them for such time. Thank you for that. Aşiyan, my last question for you, and it's because I think Pakistan is also looking now, because they didn't before, to sign the Singapore Convention. I'm hoping that you can explain that how has Turkey signing the Singapore Convention helped?
We haven't ratified the convention yet.
Oh.
We have signed in August, but in order to, after the ratification, you need to adopt your internal laws and regulations. I think right now, as I mentioned, Turkey is in preparation to adapting the law. Possibly it's going to have some change according to Singapore Convention as well. And if you look, the many Turkish companies are doing businesses outside of Turkey, and also there are lots of international transactions going on in Turkey as well. And mainly from the companies, what I'm hearing, especially for enforcing the decision. And even if they settled through mediation negotiation, to whether there's a problem in the settlement, how they will enforce was an issue. I think in that sense, Singapore Convention, especially, this is the reason that many countries are interested in. It's going to be, you can apply that decision in the other countries as well. And so it is increasing the enforceability of the settlements. So in that sense, I'm seeing is quite beneficial. And also for the big disputes, it will increase the amount of using mediation. And if many countries signed, but we are not sure whether they will ratify and enter into force according to that. So we will see, but I believe that it will increase the use of mediation, especially for international commercial cases. And for the COVID term, we are seeing how many businesses affected. And as I give an example for the supply chain, for many companies, as getting the goods from somewhere, producing in somewhere, and transferring the other country. So it's multicultural. There are many disputes going on. I think mediation is a good way to involve such conflicts. That's why also Turkey interested in like big sectors, construction, and for the many construction companies doing business in outside of Turkey, and they having many problems. That's why I think they will use mediation more after that we ratify also Singapore Convention.
All right, thank you so much. Thank you so much, Aşiyan, for giving us a whole overlay of what the Turkish model of mediation is. And I have greatly benefited from your expertise and experience in the area. And I will be exploring these models and how we can help Pakistan get to the same place as well. Thank you so much. I will now be moving on to the arbitration part of our webinar today. And I will be talking with Miss Ece. Ms. Ece, moving on to arbitration, how does Turkey perceive arbitration and what is the arbitration culture in Turkey?
Well, arbitration is relatively new in Turkey. In my experience, the first reaction of the Turkish people to the arbitration was completely ignoring and mistrusting the procedure. It was out of lack of experience and solid knowledge, as well as the mere result of holding on to the traditional way of doing things. I mean, the litigation. However, this did not concern those who were players of international area and part of international transactions. This type of businessman literally imported the procedure by taking part of it. It is also common that parties ignore stipulating arbitration clause in the main contract. In that case, it is not very uncommon to refer to arbitration through an arbitration agreement made after the main agreement. From my point of view, arbitration is trending in Turkey now, not just because it is flexible, as I've mentioned before, but also because it is speedy, let alone the emergency arbitration. It's also I find it also intriguing that maybe because the arbitration culture, dare I say, started becoming a part of our culture, now the litigation process takes far less time than ever. It still does take a lot of time and effort compared to arbitration, but at least now in Turkey, there's a time limit set at the beginning of each litigation case. Long story short, arbitration has evolved in Turkey together with litigation. How does Turkey perceive arbitration? It is and has always been a part of our culture to negotiate and come to terms in the end. The mere act of negotiating, the Turkish people find that, dare I say, satisfactory and thrilling, no matter what the result is. It is done for the sake of the negotiation. Nowadays, it has become more common and acceptable to refer to arbitration in Turkey. The İSTAK, Istanbul Arbitration Center, was the main investment made for the future of the arbitration in Turkey. On the other hand, parallel to Turkey being the attraction point of tourism, it may one day become the attraction point of arbitration. Having said that, I refer to Turkey being chosen as the seat of arbitration.
Can you elaborate that what is the arbitration model in Turkey and what kind of arbitrations are common in Turkey?
Yes, I can. From my experience, the ICC is the arbitral institution most referred to by the Turkish parties. The LCIA follows the ICC. The construction and petroleum arbitration disputes are among the ones trending nowadays. However, there are some interesting cases administered by some arbitral institutions which are less popular that I came across. On the other hand, since 2015, Turkey has the İSTAK, Istanbul Arbitration Center, and has introduced the İSTAK arbitration and mediation rules, which have been drafted according to the rules of the worldwide leading arbitral institutions. It is worth mentioning that the İSTAK has come up with the world's first mediation arbitration rules, having the characteristics of both mediation and arbitration, enabling parties to use both procedures in two stages in the same proceeding. If parties do not reach to a settlement through mediation, the second step will be a binding arbitration process. Also, I would like to underline the fact that there are institutions promoting arbitration in Turkey, such as Young İstak and İsta. In my point of view, I find it promising for the younger generations because they are, Young İstak and İsta, they are inclusive in this regard. Many activities such as arbitration competitions, contests, and panels are organized by such institutions.
Thank you for that. I would also like you to let us know that how has the pandemic affected arbitration?
Well, during COVID-19, it is impossible to say that it had no impact on the procedure. Of course, it had some impact on the procedure. However, the İstak has announced İstak online hearing rules and procedures, enabling participants to conduct hearings without physical attendance through teleconference or video conference under İstak rules. In short, hearings took place online at the request of any party or in case the sole arbitrator or the arbitral tribunal deems appropriate. In this case, the documents were transmitted electronically, the right to be heard was diligently regarded. The forte of this system, alongside the hard times of COVID-19, when the physical interaction was restricted, is that the hearing is recorded by audio or video. But apart from that, I would like to mention that Turkish Code of Civil Procedure and Turkish Code of International Arbitration, they make room for online arbitration agreements to be made online via websites, etc. In times of COVID-19, it is widely known that e-commerce has escalated. Online arbitration agreements concluded via electronic means have eased this, shall I say, transitory period in terms of contracting.
All right. Thank you so much, Ece, for enlightening us on what the Turkish model of arbitration is and how has the pandemic affected arbitration in Turkey. Before we end this, I would like to ask both my panelists that how do they think that countries can develop a culture of alternate dispute resolution?
Shall I start?
Yes.
Okay. In my point of view, for the sake of the future, I would like to handle both future of the arbitration and maybe Aşiyan for the mediation and the ADR culture together. I would like to handle them together. In my point of view, for the sake of the future of the ADR, the qualified community has to expand. The courses, panels, webinars, and all sort of educational means play great importance. Being a good lawyer does not always equal to being an exquisite arbitrator, mediator, or negotiator. As long as institutions such as the ICCYAF and Young İstak promotes the ADR, be it through competitions or through panels or courses, it has great use and positive impact on the younger generation to get accustomed to the ADR mechanism. Also, the ADR has been taken even more seriously in Turkey, so seriously that mediation and conciliation have become a condition precedent for some litigation disputes before national courts. In short, I personally find the future of the ADR very promising, and I believe a country making such investments will reap the results as did and does Turkey.
Aşiyan, you would like to add something to that?
Yes, I think I will have similar comment as Ece because I also see that education is quite important. And when I'm looking for the society as a level, also Pakistan have similar issues in Turkey, and our societies have big problem communicating within non-violence way. And in these countries, especially, and now we are discussing also violence against women. As you said, also we are women mediators and arbitrators. And I'm seeing and also when I'm seeing the inside of the dispute is not sometimes business issue, not sometimes legal issue. When you look into the deep, is the communication barrier that into parties. And in order to send this type of trainings for increasing their communication skills and the way that how they see the things in neutral way, how they use the language in a neutral way, in a non-violent way, is because as a lawyer we are getting skills to represent the parties, also defend the parties in a way that we negotiate always for one side. But in arbitration and in mediation, in all ADR methods, we are looking the cases in a neutral side. So in that sense, it is increasing in the communication level and the relationships between the parties as well. I have recently settled a case as a background for 22 years. It's a family dispute. And even for me to convincing parties for mediation took 6 months. But they resolved recently, and they settled for and finalized nearly 10 cases.
Wow,
so
that's a lot.
But other than the cases, the amount of the disputes and everything, what I see that it was beneficial in the process, the family come together. They sit in the table after 22 years. So it is really developing the relationships. And I cannot see that it is coming when I first meet the parties because they were in the separate room. They don't want to see each other. But the way that how you develop the relationship, it increases also communication level in the society as well. I think this is also quite important. And the other thing, we have now, because of the internet, generation gaps. I mean, the communication in the past, the way that in the legal frame is long sentences, is all long books. We are get used to read and talking in short sentences. I think the legal community also needs to adapt itself according to simplifies the way that how they communicate, because it is also inside in the legal community creating another community. Even we are not interpreting the news and laws and regulations quite clearly because you don't understand what does it mean. So in that sense, I think the way that how we use language needs to be simplified and adapt according to new generation, because otherwise, if we see the future of disputes, and the gap between the internet and legal community is opening more and more. And the way that the speed, the way that the development is, when you look at the legal community, it's quite slow. Actually, it doesn't have a power to catch up either. So that's why we need to change our position and try to find a way to think in a differently. So in that sense, I think the countries that thinking in that sense will catch the future. I believe so.
I hope so as well. Thank you so much, Ms. Aşiyan and Ms. Ece. It was a pleasure hosting you guys today. And I hope that my audience have benefited from your experience and your expertise. And I'm hopeful that my research think tank will also be benefiting from these comparisons that we can take with comparing them to Pakistan about their model, if there is going to be one. So thank you so much. It was a pleasure having you guys with us. Thank you so much.
The pleasure is ours. Thank you for hosting us.
Thank you again.